A mediation information assessment meeting, or a MIAM as it's sometimes referred to, is a one-to-one confidential meeting with a mediator who's qualified to determine if mediation might be a suitable means of helping you to resolve differences with your ex-partner. At the MIAM, the mediator will hear from you about your situation and what you are looking to try to resolve, as well as explaining to you the different options that might be available to you to help you to resolve the dispute, and looking at the benefits of mediation and how they think mediation might be helpful in your circumstances without the need for a court application. A MIAM meeting lasts between 45 minutes to 1 hour. This is an entirely confidential meeting, and the discussions from the meeting will never be shared with your ex-partner or anyone else outside of the organisation. At the end of the MIAM meeting, you can decide if you wish to consider mediation or not, or whether any other form of alternate dispute resolution might be your best course of action. Even if you decide you don't want to mediate, we are required to contact your ex-partner and invite them to attend a MIAM on their own too. They may well say that they want to do mediation, and we then will need to contact you to discuss this further. One of the things that people often ask us is, do I have to attend a MIAM? Well, that's a really important question, particularly for those folks who are looking to potentially start a court process. It is actually a legal requirement there for you to consider attending mediation by attending the mediation information assessment meeting. It's important to know that you must attend a mediation information assessment meeting with a fully qualified mediator in order for that to be considered relevant to the court. It's the mediator's job to determine if they feel that mediation is suitable, and at this stage, whether or not mediation is going to go forward still remains voluntary for you. The mediator can sign a certificate to say that mediation isn't proceeding, to indicate to the judge why mediation is not going to happen. If you or your ex-partner is considering applying to court, then you are required to consider attending mediation by coming to one of these meetings. The court may also direct you back to a MIAM and mediation if you did not attend a meeting with one of the mediators. The mediator can sign a certificate as part of any application to court to indicate to the judge that you have complied with the requirement to attend. And if not, why not? One of the key things that we're often asked is whether or not you have to attend a MIAM meeting. It's very important to know that if you are considering applying to court in relation to children's issues or financial issues, then you must attend the MIAM meeting with a registered qualified family mediator, save for in exceptional circumstances. It is the family mediator's role to determine if mediation is a suitable means of helping you and your ex-partner to resolve the disputes between you. At this time, mediation still remains voluntary, however the attendance at the MIAM is compulsory. If you or your ex-partner is considering applying to court, then you are required to consider attending mediation by coming to the MIAM meeting. If you do not attend, the court may direct you back to a MIAM, and they may also direct you to attend mediation. Whilst mediation currently remains voluntary, this is something that the court are considering making compulsory for all families. The mediator is required to sign a certificate as part of any application to court for children's issues or financial issues where you have not been able to resolve matters between yourselves and you are choosing not to mediate, or mediation has broken down. The mediator is required to indicate on the form the reason that mediation is not proceeding and the reason that mediation has broken down.